We shall start, sir. Good morning, sir. Good morning, one and all. A warm welcome to everyone. I am Ramyavardhini Basani, studying Electronics and Communication Engineering, third year in Usmania College of Engineering, Usmania University. Today's pending bill is Personal Data Protection Bill 2019. The bill seeks to provide for protection of personal data of individuals and establishes a data protection authority for the same. The bill governs the processing of personal data by government, companies incorporated in India, foreign companies dealing with personal data of individuals and India. So, here are some rules and regulations for the participants. Once the bill is opened for discussion, each parliamentarian will have 2 minutes to express their views on the bill. And at 90 seconds or 1.5 minutes, there will be a short buzzer. And at the end of 2 minutes, there will be a long buzzer. That's when you have to stop. If you are still proceeding, then Honorable Speaker may state that the statements given by you will not go on record from now on. When your name is called, unmute yourself and switch on your video, but don't do that in the middle of the session when it's not your turn. Please do not disturb the session proceedings. Parliamentarians, please know that you will be marked based on discipline and decorum maintained, quality and delivery of speech, time management, and standard of debate, and accordingly, there will be negative marking as well. The Google form will shortly be sent in the chat box, which is a written form where you can extend your opinion, which you are not able to do in the given time, or you can attach any kinds of proof such as images or PDFs if you are collected. This section does not have any negative marking but do carry points. Hope these rules are clear for everyone. If you have any kinds of doubts, you can contact me through chat box. Without further delay, let me introduce the judge and speaker for the session. I take immense pleasure in welcoming our speaker for today, Yellendra Randhir Garu, High Court Advocate, Standing Counsel for Insurance Regulatory and Development Authority of India, IRDAI, Telangana State. He is a standing counsel for Coal Authority of India. Randhir sir has also received his MA LLB degree from University College of Law, Usmania University. He is presently practicing at Telangana High Court on constitutional cases, administrative cases, service matters, revenue bills, National Company Law Tribunal, NCLAT. We are glad that you have accepted our invitation and heartily invite you to the event, sir. Thank you for joining us today, sir. Now, Honorable Speaker will be calling parliamentarians in order. I request you to unmute yourself and switch on the video to express your views. I present Personal Data Protection Bill 2019. The bill is open for discussion. I request Honorable Speaker to proceed further, sir.
Now, this would like to call upon Parliamentarian Bandana Gautam Raj.
Honorable Speaker and the people who are part of this session, good morning to each. As we are in the discussion of Personal Data Protection Bill 2019, I am in favor with this bill. I am going to support it because as we are having high population, which creates even more data, the data has to be protected. There may be companies, few will be leaking this data. So for that companies particularly, we need to have a policies so that it cannot do this kind of things. So regarding this, there is a joint parliament committee which made few important points regarding this bill. Firstly, it states that it is not only about the personal data protection bill, but it is also about the it made classifications of data, and it stated few things. Firstly, it tells us that it is classified. First one is non-personal data. It is not necessary to impose some restrictions on this. The next one is personal data, and it is not so sensitive. Personal data which is not sensitive includes in this, like name, address. And the third one is sensitive data. It has to be protected. And it also has like a sensitive data like biometrical data or the caste or religious data include in this. And it also classified this into two types regarding the belonging to children and belonging to adults. And the next one is critical information. In this critical information, it includes like financial data. So regarding this sensitive and critical information has to be more concerned. So regarding these points, the joint parliamentary committee made few points, like even the social media companies should be more focused on what the data is being projected, and a regulatory body exists which have powers to decide and implementary laws various provisions. Thank you. Thank you, sir.
The next, can I call upon the second parliamentarian? Second parliamentarian, Bharat Sardar. Bharat Sardar.
Sir, currently not available, sir. We will come
Okay.
back to him later.
Okay. Next, Chada Ashrit Reddy. Parliamentarian Chada Ashrit Reddy. Mr. Chada Ashrit Reddy. Ashrit Reddy. Chada Ashrit Reddy. Mr. Chada Ashrit Reddy. Okay, then we will go for the next parliamentarian. Gonu Subbarao Kulasekar. Parliamentarian Mr. Gonu Subbarao Kulasekar. Gonu Subbarao Kulasekar.
Not available, sir, right now.
Okay. Parliamentarian Govindu Mera Prabhas Nehal. Parliamentarian Mera Prabhas Nehal.
No, sir.
Parliamentarian. Okay. Next parliamentarian H. Giri Santosh. Parliamentarian
Yes, sir. Yes,
H.
sir. I'm there.
Giri Santosh. Yes, yes. Can proceed.
Good morning to the Honorable Speaker and my fellow parliamentarians. Now I'm going to speak about few aspects in this bill which makes me to support this bill. First point is the controlling the flow of data. As India is getting digitalized, the data which we are creating now is immense, and we don't know exactly where the data is being stored and how the data is being used. The data is flowing everywhere without stoppages. So this bill is asking, so this bill is classified the data into non-personal, critical personal, and sensitive personal data, and there are giving different security parameters for each kind of data. Second point is the right to privacy. The main purpose of this bill is to protect the data of citizen. As 9 judges of Supreme Court stated that right to privacy is also a fundamental right of a citizen, and we must protect our fundamental right.
Yes.
And this bill is ensuring the right to privacy of citizens.
Yes.
The third point is this bill is giving most important position to the consent of citizen. As this
Yes.
bill is saying that no data can be processed without your consent.
Yes.
Personal data can be processed only for specific, clear, and lawful purpose with consent. And my fourth point is about data protection authority. This bill is asking about to establish the data protection authority, which have the role to regulate and monitor whether the data is being protected or not. If there is a data breach, the data protection authority looks into the breach, and data fiduciary also has an obligation to inform the data protection authority. As this bill is saying, as this bill is ensuring the right to privacy, this this is setting up for rules for how your data is being going to processed. This bill is giving confidence to that your data is being protected. So I'm going to support this bill.
Okay.
I'm concluding. Thank you.
Okay. Then next parliamentarian Mathu Srinija.
Sir, am I audible?
Yes, yes. Yes, you're audible. You can proceed.
morning, everyone, Honorable Speaker, and members of Parliament. Privacy laws have never been as important as they are today. Now that data travels the world through borderless networks. Over 130 jurisdictions already have the data privacy laws as of January 2021. Before I give my reasons in support of the bill, I would like to acknowledge that there are a few areas in the bill that would require amendments. For example, the exempt of consent for any function of state. But other than that, I completely support the bill. As per the recent report, India ranked third in the world in terms of data breaches, with a total of 86.63 million Indian users breached till November 2021. This simply shows the grave necessity of the bill. The PDP bill in 2019 was recently reviewed by the Joint Parliamentary Committee report and was presented in the winter session. The report suggested 93 changes and amendments to allow the non-personal data to also be looked after by the current bill in place. The data collectors are also subject to various new reporting requirements. For example, the bill imposes additional requirements such as the requirement to obtain a parent or a guardian consent for the collection of data belonging to children. The bill will legalize privacy, penalize its offender, ensure significant reduction of fraud and misuse of data, also generate a centralized data repository. This bill will put an end to the rampant misuse of citizens' personal details and by other countries and force data controllers and processors to localize the data and significantly minimize the amount of unnecessary data collected. Thank you, sir.
So, next parliamentarian, Meghana E. Parliamentarian Meghana.
Not available, sir.
Okay. Next parliamentarian Menda Srivardhan Yadav. Next parliamentarian Menda Srivardhan Yadav.
Hello?
Yes, Mr. Srivardhan.
Am I audible?
Yes,
Yeah.
yes, you're audible. You can proceed.
Good morning to Sir Speaker and my dear dynamic parliamentarians who are present in this assembly. As we are in an era of the internet, everything of our life is of our personal data will be shared to the world. We feel that the privacy policy of a company which we use uses our data and helps and keeps it privately. But as we cannot stop anyone giving, as everything is getting virtual from local institutions to international level institutions. So the personal data bill comes in the background so that the need and necessity to share the data of personal so that anyone cannot intrude into the personal space of an individual. Yes. And this bill tends to protect the personal data of individual. And this will create a framework so that our data is stored and processed in a safe place. Previously, we were having IT rules 2011 under the Information Act 2000. Now this is regulated. This is going to be regulated by Personal Data Protection Bill 2019. As the growth of digital media and economy has outdated the IT rules 2011, and it was having many flaws. For example, the IT rules 2011 were only applied for private companies, not for the government agencies. But the Personal Data Bill Protection Bill is applied for both government agencies and the private companies. And it gives some certain benefits for the people. Any individual that this protection bill also create an agency for the individual to ask his data if there is any breaches, and it allows the person to readdress if there is any grievance in data for the private companies, and the private companies are liable to compensate this person, and the government can also use this data if required for providing benefits such as Pradhan Mantri Jan Dhan Yojana. And I want to conclude that once Supreme Court said that the life doesn't mean clothing, food and shelter, food, shelter and clothing. We are celebrating Azadi Ka Amrit Mahotsav. In this time, also we should our India should not face the issues with privacy. I feel this bill is well equipped to solve those problems. And thank you. Jai Hind.
Next parliamentarian N. Gaurav Srinivas.
Yes, sir.
Yes, Mr. Gaurav Srinivas, you can proceed.
Okay, sir. Thank you. Good morning, Speaker Sir, my fellow parliamentarians and organizers. I am Gaurav and here to present about the Personal Data Protection Bill. I would like to talk about why this bill is very necessary at this point of time. Because wherever we go, whatever service we use, whichever platform we are on, any different kinds of data of us are being collected on different platforms. So, as right to privacy is our basic right, knowing how this data is being processed, how it is stored, where it is being transferred, and what is being done with this data is our basic right. So I feel that this bill gives us all the information that we need about how our data is being processed or used or transferred, and gives focuses more on our consent. So I support this bill, and I've observed some disadvantages in the bill, that when there is low data localization, and where fiduciaries outside India have to be established in India and have their database outside India, it would be a little difficult for them to transfer data or store it in India itself. So recently, the Joint Parliamentarian Committee came up with a solution that if the data principal gives their consent, it can be the data can be transferred to other nation. So this solves that problem, and there are a lot of advantages, like it can uh, solve the cyber attacks and monitors how the data is being processed, and a lot of advantages which overcome the disadvantages, like the relaxation given to the government by using broad exemption terms like security and fiscal interest and national security and all this. Thank you, and I feel this bill is very important in this point of time, and I completely support it. Thank you.
Okay, Mr. Gaurav. Next, parliamentarian Neetal Anurag Teja. Mr. Parliamentarian Neetal Anurag Teja.
NP21 is not available, sir.
Anurag Teja is not available.
No, sir. No, sir.
Mhm. Then Nikit Madhav Kodichetti.
A very good morning to everyone. I am in favor of passing this bill because the right to privacy is a fundamental right and it is necessary to protect it. I feel that this bill aims to achieve that. This bill addresses the main concerns of data collection, such as non-consensual collection of data, collection of more than necessary data, and not deletion of data after the purpose it was collected for. Data is non-consensually collected only for legal proceedings or the person is benefiting in any way by the collection of data or during medical emergencies. By setting up Data Protection Authority of India, we can rely upon this government body to protect our data. The persons processing data of individuals are accountable to and responsible for the data which they are handling. People can report to this government body if any harm is caused or likely to be caused by the collection of data and termination of the persons who violate the procedures stated by the bill in handling any data of the individuals. Although prevention, detection, investigation, and prosecution for any offences, the bill states that the data should be clear, specific, and lawful, and no other regulation. I think prevention, detection, investigation, and prosecution of offences are state functions and are in the best interest of the public. The pros of this bill outweigh the cons, so I am in favor of passing of this bill. Thank you.
Okay. Mr. Kodichetti left. Next parliamentarian Praful Vaidya.
Not, sir, he is not available, sir. Not joined yet.
Okay. Then Rahul Shriya Bhanu, parliamentarian Rahul Shriya Bhanu.
Yes, sir. A happy morning to Honorable Speaker and my fellow parliamentarians. The growth of digital economy makes data a crucial means of communication. As technology is increasing day to day, it is necessary to protect individuals' data. I support this bill as it provides trust relationship between data fiduciary and data principal. It provides right to be forgotten. That means the right to correct the data, confirm whether the data has been processed, or to restrict when it's continued disclosure. Bill allows certain exceptions from many of its provisions when data is processed in the interest of national security or for prevention or investigation or prosecution of offences. This bill also set up a national level data protection authority DPA to supervise and regulate data fiduciaries. This bill also appoints data protection officer for each and every company to supervise the data. Thank you, sir.
Thank you, ma'am. Next parliamentarian Sushma Akula.
Good morning, Honorable Speaker and members of Parliament.
Yes.
I support the idea of personal data protection, but it has many loopholes. I am against the act. From the time of committee, they didn't give the clarity to many people. There exist broad conditions which can make the government and other entities to collect data without consent and also deny essential services. While several users are present, user rights are present, rights such as being exempt from automated decision making are not guaranteed to people. Further exemptions and carve outs need to be re examined. The provisions with regard to social media entities using government IDs for verification is completely misplaced. I would have several harms. It would have several harms, increasing surveillance and profiling. Until the clarity is given to all the members of the state and or country, I would uh, I will be against this act. I support the idea, but there are many loopholes which are to be covered, and I will completely support it when they are cleared.
So, are you proposing any amendments, ma'am, in regard to such remove those loopholes?
I'll I'll think about it, sir. Like social media entities um using government IDs. That means social media entities are also using the government IDs, which will be misplaced, sir. It may be misplaced.
Of course, all these loopholes are available in this legislation. In order to remove these loopholes, in the parliament, you have got, being a parliamentarian, you have got an authority to move a private bill, or you can move a private amendment bill to propose an amendment to the provisions that which has been incorporated in the bill. It's up to you. So anyhow, you would like to oppose the bill, isn't it? Ms. Sushma Akula. Can you hear me?
Yes, sir.
Okay, you are opposing the bill, isn't it?
Yes, sir.
Okay, okay. Okay. Then next parliamentarian, Sutrapu Rahul. Sutrapu Rahul.
Not
Mr.
available.
Okay. Next parliamentarian, Seddu Shenmukh. Seddu Shenmukh.
No, sir, not available.
Next parliamentarian, Vedhanvita Gudavalli. Next parliamentarian, Vedhanvita Gudavalli.
No, sir.
Okay. Next another parliamentarian, Yasmin Begum. Parliamentarian Yasmin Begum.
Not available, sir.
Okay. Then Parliamentarian Vishal Chandragiro. Parliamentarian Vishal Chandragiro.
No, sir.
Okay. Can we go to the first non-appeared candidate?
Yes, sir.
Call his
They
name.
will.
Banu Sardar. Mr. Banu Sardar. Parliamentarian Banu Sardar. Then the Parliamentarian Chara Ashrita Reddy. Parliamentarian Chara Ashrita Reddy. Then Parliamentarian Gonu Subharao Kulesekar. Parliamentarian Gonu Subharao Kulesekar. Then Parliamentarian Govindu Meera Prabhas Nehal. Parliamentarian Govindu Meera Prabhas Nehal. Parliamentarian Meghana. Then Parliamentarian Nathan Anurag Teja. Then Parliamentarian Praful Vaidya. Parliamentarian Praful Vaidya. Parliamentarian Sutrapu Rahul. Parliamentarian Sutrapu Rahul. Then Parliamentarian Vedanvita Gudavalli. Vedanvita Gudavalli. Parliamentarian Yasmin Begum. Parliamentarian Vishal Chandragiro. Parliamentarian T. Shenmukh. Parliamentarian T. Shenmukh.
I guess
Teddy
Shenmukh is available, sir.
Yes, yes. Parliamentarian Teddy Shenmukh.
Sir, I'm available, sir.
Yes, yes. You can proceed.
A very good morning to Honorable Speaker and to the members of the Parliament. I rise to oppose the bill. I would like to begin by pointing out at the clause 1 of the bill, which states that no personal data shall be processed by any person except for any specific, clear, or lawful purpose. The term lawful has to be explained in great detail. Just a mere clause without any subclause is not enough. With this, we want to point out the role of government in the recent Pegasus scandal. Since the rollout of the documents consisting the names of the Pegasus victims, the government has always maintained a single stance of no comment. But when the Honorable Supreme Court has asked state for clarification, the state seems to have only one answer: national security. If national security was a real motive, then why does the document only consist the names of leaders of opposition, their children, and their relatives? With this, I would also like to point out the clarification of clause 5, which states that the personal data shall not be processed except on the consent given by the data principal. Now, this, I believe, is a double-sided sword, because in the current market, there exists no app or software or website which would run without certain amount of data being shared and cookies being accepted. I would like to ask, has the government taken this into consideration? If yes, then why isn't a single clause stating that there would be action against the individual or an organization who would not abide by this? Through clause 10, it's rather clear that government has now legalized the sharing of sensitive data outside India. But does the government has any mechanism to monitor the data that's shared outside India and to make sure that the data isn't misused outside India? With this, I would like to conclude. This bill is of absolute necessity, and it's the need of the hour. Data is the new oil, but the clause 1, 5, 10, 12 seem to be rather incomplete, and certain clauses seems to be missing. Thank you, Honorable Speaker, for this opportunity.
So would you like to propose any amendment in order to that particular clause, in order to interpret the word lawful? Under the interpretation clause, section 2, definitions of words that which would be used in a bill. So for the purpose of particular word like lawful, so what is the definition that which you would like to propose to the government? Would you like to bring any private bill to that effect, bringing an amendment to that particular clause?
Yes, sir, definitely. I want the government to make the word lawful much more detailed. I want them to explain the charges that they are going, all the IPC.
No, you're being a parliamentarian, you have got authority to introduce a private amendment bill to that particular clause. Therefore, amending the term lawful which is very opaque and vague and inclusive, to constricting it. What is the definition of lawful means? You can bring a definition to it under section 2 interpretation clause. Interpretation clause of any act or any bill, you can bring a definition. You can bring a private amendment bill to amend the definition, or to bring a definition, or to constrict that particular word. Meaning
Sir,
of that word.
Sir, I would like to add the term, the same meanings that we have used, the same terminology that we have used for UAP Act. All those charges have to be brought back to even this term, sir. So the clause, all the remaining charges that they're going to put in UAPA have to be clearly mentioned here, sir. These are the charges. So I want them to use all the
What is
UAPA
the,
terminology.
so you want to even questioning in relation to the adjudicating authority under this act. So there is no adjudicating body under this act. If there is any violation of the data provision, data privacy or data, so do you find any adjudicating authority for which an individual or single citizen can approach in order to redress his grievance in relation to his privacy violation?
Yes,
If
sir.
there is no such kind of adjudicating authority, would you like to bring any such kind of private motion bill to amend?
Yes, sir.
The bill in
Definitely.
order to bring in that adjudicating authority.
Yes, sir. We would definitely appreciate if the government sets up a board which would look after all these grievances in certain time and
Government
having
brings,
a
and
time
also
of 14 days.
government bills. You are a parliamentarian. You yourself can bring a private bill to that effect, isn't it? You can move a private bill amending the provisions of the bill. Being a parliamentarian, you can move that bill. So I am posing a question: will you bring any such kind of amendment to the provision, creating a separate adjudicating authority?
Yes,
For
sir.
the
Definitely.
violation of the any of the privacy or the data of an individual, means any citizen.
Yes,
If
yes,
there is
sir.
any
Definitely.
grievances to any citizen, he needs to approach certain adjudicating authority. In normal sense, there is a court for the civil matters, so civil court is there. But there is any such kind of tribunal existing for the purpose of violation of any of these data or any privacy related incidences or instances. Do you find any such kind of adjudicating authority being created by this act?
Yes, sir.
If
Definitely. I
no, would
want.
you like to? If no, would you like to bring any private bill to that effect, amending it?
Yes, sir. Definitely.
Amending
I
the
would
bill
like
to
to
bring
bring
it.
a bill, sir, similar to consumer forum that we have current existing. We would also want a board to be set up there which look after all the grievances. And apart from this, we want the government to mandate every organization like Twitter, Facebook to have its own grievance officer who reports directly to the board setup.
Yes. Okay.
And an authority is given an answer for every grievance within 14 days. We want this to be mandated in that authority, in that board, sir.
So you can bring a bill to that effect, amending to that provision.
Yes, sir. I can bring a bill,
Okay,
sir.
okay. Very good. Very good. Hello, Vedanvita Gudavalli is present. Parliamentarian Vedanvita Gudavalli.
No, sir.
Parliamentarian Yasmin Begum. Parliamentarian Vishal Chandragiro. Parliamentarian Vishal Chandragiro.
No, sir.
Okay. Whether anyone other than those people who have participated have arrived?
No, sir.
Banu Sardar or Chada Ashita Reddy, Gonu
No.
Subharao, Kulisekar, parliamentarians. Anyone who would like to make their point, any parliamentarians who have not yet
Yes.
represented, you can represent.
Honorable parliamentarians, this is the last chance and the final call for you. If you have not yet put your points, this is the
You
last
can
chance.
represent all the parliamentarians who have not represented yourself. You can represent now. This is the last chance. This is the last and final call to you. Any of the parliamentarians who have not appeared, who have not presented their points, who have not moved their motion, who have given the notice, but who have not appeared, You just assume it as a last question, or anyone can represent their view. No one.
Okay.
Okay.
Okay, the final
Let's go
call
ahead.
has been, yes, sir. The final call has been completed. So let us move to the second round, sir, with your
Yes.
permission. Yes, sir. The second round is rebuttal round, where every parliamentarian who has any statement or question can put their IDs in the chat box. Honorable Speaker will give their chance accordingly, and the parliamentarians who had mentioned their IDs can speak, then can ask questions or any of the parliamentarians, and the parliamentarians who want to oppose or support the statement can raise their hand. Are the rules clear? Parliamentarians having any questions can put their IDs in the chat box. Honorable Speaker will be calling out your IDs so that you can question or support any of the parliamentarian. And important thing to note that you will be only having 30 seconds to ask a question or to counter a statement. In the 30 seconds, you need to finish your views. At the 30 seconds, there will be a buzzer. So, let's start the rebuttal round, sir.
Yes, yes.
Parliamentarians who are having a questions or to counter anyone can put their IDs in the chat box. Anyone, if you have extra points, extra views also can put your IDs in the chat box. Yes, we have an ID in the chat box here.
Oh, yes, Mr. Shanu. You can raise the question.
Yes, sir.
Sir, sorry for the technical issue. Honorable Speaker, I want to know the government stance on why is being other number mandatory for 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 every government document that is going to be provided by government. Only mere ID, mere any other document can also be used for ID proof and address proof like passport and
Yes, yes.
like driving license and PAN card. But why is being Aadhaar linked to everyone? And what has the government done to see that there are no breach of data that's happening in case of Aadhaar cards? And we have seen a lot of reports and speculation that a lot of data has been breached prior to authorities of Aadhaar.
Anyone to counter that?
Parliamentarians who are in support of the bill, this holds good for everyone. So if you have to counter, you can raise your hands. You will be given a chance by Honorable Speaker.
Anyone? Then Gaurav Srinivas. Would you like to counter?
Yes, sir, I would like to.
Parliamentarian? Yes, yes.
I would like to counter by saying that Aadhaar is something like a basic ID proof that we have. A lot of people don't have their driving license or a PAN card or a lot of other documents. So I feel, yes, the government is not guaranteeing that this data is not being breached, but I think linking Aadhaar to something can uh, help us, like, not creating a lot of fake extra data or taking the data or something like that.
Okay. Anyone would like to counter it? Anyone?
Parliamentarians, this is to note that this debate and the rebuttal round carries marks. So we request you to actively participate in it. If you want to counter or support any statement, please raise your hands. Yes, sir. MP22 has raised their hand.
Yes, Mathu Srinija. Yes, Mathu Srinija, would you like to counter?
Sir, Nikit Madhav, sir, I would like
Nikit Madhav,
to
yes.
support the statement, sir. Aadhaar is the proof of identity of Indians, sir. It may not be proof of citizenship, sir, but it is mandatory and almost all of the citizens have it, sir.
Mhm.
So I would like to consider it as the basic requirement for every citizen to have, sir. This is why all some people may not be having bank accounts who are minors who may not get PAN card or passport by the time they are 18, but they can get Aadhaar card, sir. It is basis necessity, sir. So I'd like to support this statement, sir.
So whether you'd like to bring in any provision in relation to Aadhaar Act?
Can I speak about this?
Yes, yes.
It can establish a committee or a board which regulates how the data is being processed or being used, and the consent of people is taken before being used in any for anything. Can be amended so that it is not misused and people know how the data is being used. This can be done, and also allowing them to uh, make Aadhaar card as something basic.
Whether anyone? Mr. Shanmugh, would you like to counter?
Yes, sir.
Mm.
So government seems to not even deny, sir, that there has not been any breach. But we want to ask, Aadhaar card came into existence just 10 years before. So just 2009, it was introduced by Congress government. But still, there were in the 70 years of our history, there was never a breach of passport data. There was never a breach of driving license data or ration cards data. Now, all of a sudden, how did they manage to breach all the data of around 1 billion Indians? They have mentioned that it's identity of our Indians. How can the government be so negligible when it comes to Aadhaar, when it has all the biometrics, not just the name, address, it also has the biometrics, retina ID, eye retina, and fingerprints also, sir. So why has this been given to a private authority? Why can't Indian government could have taken, as in the case of ration card, as in the case of passport, as in the case of driving license?
Okay. Anyone to counter that point?
Sir.
Yes.
After the other case which has happened in the year 2017 also, there was a committee set up of judges, 9 judges. At that time only this bill, the Supreme Court has said that this bill, which is the bill called Privacy Protection Bill, will help data protection bill, will help the people to access their to store their data personally, and the authority would be set up so that the data breaches would be cleared. There is a statement in the bill actually which to ensure.
Which is that? What is the judgment? Can you name the judgment? Constitutional bench judgment.
uh,
Swami versus Union of India. What is the judgment that which you are quoting? You stated that the Honorable Supreme Court has rendered 9-judge bench judgment in relation to the privacy.
Hello.
Can you hear me? Can you hear me? Can you hear me?
Yes, sir, you are audible.
I am audible. No, you are quoting a judgment rendered by the Honorable Supreme Court in relation to the data privacy. Can you name the judgment? Okay, anyone, any parliamentarian can name the judgment in which the Honorable Supreme Court has granted permission for the limited permission to the government in order to use the Aadhaar. What is the name of that case? Constitution Bench Judgment. It's a 9 judges Constitution Bench Judgment. The Honorable Supreme Court has gave a limited authority for the limited purpose in order to use the Aadhaar. Any of the parliamentarians can name the judgment. Judgment is Puttaswamy versus Union of India. Justice Puttaswamy versus Union of India. The Honorable Supreme Court has granted the limited permission to use the Aadhaar. It's a Constitution Bench judgment, and it is the basis on which the data protection bill is being framed. It's a 9-judge Constitution Bench judgment. Anyone? Mr. Shanmugh, would you like to rebut?
Not rebuttal, sir. I have I seek a clarification about clause 4, sir. Can I start?
Yes. What is that?
Clause 4 states that the government has now legalized sharing of sensitive data, sir, and it has said that it cannot share any critical data cannot be shared. But the government has not mentioned anywhere that what data comes under sensitive data and what does it consider as critical data. And they've also said it can be data can be shared, but data can be shared, but data will be stored in India. Then if the data is already shared, then what's the point of storing in India, sir? So I see clarification by the government about this.
Anyone who would like to counter this?
Yes, sir. In the chapter 7 of the bill, the government tells that only with the consent of the data principal, the data can be transferred to any other nation, but being stored, but can only be stored in India. So, as the data fiduciary is having the consent of the data principal, I think it is fine for them to transfer the data outside India.
Okay. Anyone?
Yes, sir. I support the statements by MP20. Under this bill, the government will have the rights on under this law. If this turn into law, the government will have an authority to have a control over private companies which are in India, and the data which is shared by the individual for the foreign companies, and the data can be taken back if the individual is willing.
Okay.
Also, I would like to mention a point that in this bill, the recent JCP committee report tells that if there is any data breach in the data fiduciary, it should report with all the details of the breach within 72 hours, and it will be held responsible. And few other points that have been given by JCP committee, that serious action will be taken against the data fiduciary, and that 2% and 5% of its overall turnover needs to be paid as fine if there is any data breach. So I think these rules are made so that no breach or.
So there is already a penal provision there. Penal provision is available in the data protection bill. Those who violate any of the data of any of the individuals, then they can be penalized. That is what your point, isn't it?
Yes, sir.
Okay. Anyone?
Sir, but the provision only tells if at all there's an intentional breach by the company or negligence, but they are not considering cyber attacks, which is a non-intentional breach. But what's the matter of the data when it's a non-intentional breach? When what happens when a cyber attack? Then the body under which we have given the data is not liable, then who takes the liability of the data which has been breached under these attacks?
Cyber attacks are not unintentional, it is intentional. Cyber attacks are intentional, these are cyber crimes which are covered under Information Technology Act 2000, isn't it? These are all crimes.
Yes, sir. What I mean
Crimes
is,
are intentional. Mensidia is there. Under crimes, mensidia is there, intention is compulsory presence. Irrespective of the fact whether there is such kind of cyber attacks, then what is the protection that which the government would like to offer is your point, isn't it?
yes, sir. Who would take the
Who would be made responsible for
who
such
would be
kind of
made,
cyber attacks?
yes, sir, who would be made responsible, and what is the next course of action that government wants to follow? And now the authorities do not have anything in their hands to bring back the data. The data is already sent. So what are they going to do, and what are the additional things that the government wants to add in the bill so that none of this happens? And minimum regulating points that security regulations, cyber security regulation that they want to add, we want to know, sir.
Yes, anyone to read?
So these are some things that the government can look into or try to make amendments and bring in much better terms and authorities so that nothing this sort happens. But these are the very few disadvantages that we see, which the advantages of the bill are much more than the disadvantages. So at least getting something like this into the society, in making it a law, will help us. Like, it is like a kickstart for us to protect, instead of like completely letting it go or completely repealing this law. At least introduce this and make amendments in the future so that the data is properly protected, and because everything is not perfect, we work on a feedback loop. So we introduce something, we take the feedback, we again improve, we take the feedback and again improve. This is something that I would suggest, and that is why I decided to.
So you can say that there is already a mechanism which is established in another act, another legislation called as Information Technology Act, where if there is any such kind of cyber attack, which is an offense, punishable under law, and a criminal case has to be registered. And the cyber attacks or thefts are, all these things are quite common. So now the point is that the misuse of the data by the individuals under their control is the main purpose of this data protection bill, isn't it? And also providing the security that the data that which is under their control has to be, that there shall not be any negligence, where any prudent person or any person, by looking at those data or the position of the data in a file, that it is not in a position to be corruptible. All the precautions has to be taken. If that is the standard, then that itself is enough.
Yes, sir. And there are 2 points that I missed to tell, sir, that the data should be collected only till the extent that it is necessary, and the fiduciary can only retain the data until the period it is necessary. So after that, it should erase the data. So when, for example, I give my data, the period of necessity is done, the data is erased. So even if there is a breach that is happening, there is no old data that is being collected, because time to time the data is being erased after the use.
Okay. Then anyone? Any parliamentarian who would like to?
Sir, I would like to seek clarification about clause 12, sir, which mentions that the chairperson or the chairperson of the board that they are going to set up will set up to look into these offences will be headed by a cabinet minister of the central. But we want to know, this cabinet minister is going to work under the laws of central government. If at all he wants to, and there's a great scope of misuse of power. He can act bias. So we believe here the head of the board should not be a cabinet elected person, rather be a person from all India services like an IAS, IPS, or any of the other equivalent authority, but not a elected representative, so that we can reduce the bias in case of investigations of such kind.
Even if he's an IAS officer or any other authority, he is completely under the central government, isn't it? He is an employee of the central government. How can he be without a bias? He is already part and parcel of the central government. He is working with the government, and if the government itself breaches, the same government itself is acting as a adjudicating authority. He is the one committing, he is the one abusing it, and he is the one acting as the person who is adjudicating these abuses. So how can he be both? How can he be an accused and how can he be a judge in his own case? Don't you think it is violation of principles of natural justice?
So this I believe it would be a personal choice of an IAS or IPS whether he wants to work sincerely or rather take the direct command from central government. And in state government the tenures are not fixed, but in central government tenures, the central government certain position tenure.
Whether it is tenures or not, they are working under the central government, isn't it? They are the part and parcel of the executive. Since the executive itself is abusing the authority, the very purpose of bringing this protection bill is for the purpose of not to misuse any of the data that which we give it to the government or any other authority. If the government officers itself are misusing it, and then you are making these government officers as judges in their own misuse, that means a single person is an accused and he is also a judge. You cannot make it. It amounts to the violation of the natural principles of natural justice, isn't it? No person can be a judge in his own cause, isn't it? There is a Latin maxim, "Nemo juris causa insua." No person can be a judge in his own cause. And audi alteram partem. Other person should be given. You need to hear the other person before forming an opinion. So here, a person being a judge in his own cause, the central government violating data protection or data privacy is appointing his own authority to judge. That itself is violation of the principles of natural justice, principles of separation of powers, that which is enshrined in our constitution.
Sir, I would like to quote. Yes, sir. For this clause, for particularly for this, in a 1951 All India Services Act, there is a clause which mentions, and All India Service and person who has the authority of All India Service has a freedom to not to be biased, sir. It's his own will. If he wants to,
I cannot hear you.
It's his duty, sir. It's part of his in All India Services Act. It's mentioned that he can be he has the freedom when he's the board of chairman of a particular board. He has the freedom to take his own decisions, and if at all he's being pressurized by any of the he has a right to approach the Supreme Court.
Can you? I cannot. I'm not audible. It is not audible to me.
Can I repeat it, sir?
Yes. Yes.
So for especially for that, sir, I would like to quote 1951 All India Services Act, in which there's a clause which clearly states that if at all a board of authority is one chosen from the All India Services person, he's being pressurized to make a biased decision. So it's his own will. If he doesn't want to follow that, he can approach the Supreme Court. If he's being pressurized,
he cannot be approaching. The point is that it is a will. It is an independent will. They can make an autonomous body. Instead of choosing for something or the other, they can create a tribunal where they can appoint a former Supreme Court judge or former High Court judge. An autonomous body can be created. An adjudicating authority can be created. Being a parliamentarian, you can propose such an amendment, a private amendment, by bringing a private bill to move a private bill tribunal, creating a quasi-judicial authority. If there is anyone who would like to counter? Any parliamentarians?
So, in India, there are many people who don't know about the cyber crimes, and also even they don't know how to protect their details. But governments, how would they know if to give the personal data to government, or are they giving to the government or some other persons? They even can't uh, define or they cannot differentiate between the government and other officials because they can be easily negotiated. So how can we prevent that?
Okay. Anyone? Any parliamentarians?
Sir, people with such less awareness about all the services that are available, I don't think they'll look at service schemes or welfare schemes. So, to only availing those schemes or approach only. And as I already mentioned before, that only the data which is required will be collected, and for the only necessary time it will be collected and then discarded. So I think
So
that
what
should
is
be.
the punishment? What is the given provision? Whether there is any provision for punishment for misuse or abuse of the personal data in the data protection bill?
Sorry, sir. I didn't get it.
Can you hear me? Whether there is any such provision for punishment or punishing the government authorities or private authorities for misuse or abuse of this data of private individuals? Whether there is any such kind of provision in this data protection bill?
No serious provision is provided in the bill, sir, of
Then you
especially
can bring
for.
an amendment to that effect.
Sir,
Not
actually,
deter the person not to. Yes, yes. Anyone?
yeah,
Yes,
there
please.
is a, if there is one thing actually in the bill. If there is any grievance by the company, if that breach is very big, the breach is small, the company should pay to the individual 5% of his whole company value, or some 5 crores.
Okay.
If data breach is very big, the company has to pay 10% of total what is it called, company value,
Asset value of the
or
company.
10 crores.
Okay.
This is their,
Maximum. Okay.
yes.
So this is incorporated. Okay. Fine.
Sir, we wish to ask the fellow parliamentarian to quote the act in which the following quotation that made by the parliament exist.
Yes. Yes. Yes, Mr. Parliamentarian, Mr. Yeah. Previously, Mr. Srivardhan Yadav. You have just quoted a provision of fine. Can you tell me the clause under which section, under which clause of the data protection bill you are citing it?
Yes.
Your fellow parliamentarian has posed a question under which section it is you are citing that particular punishment, wherein the company has to pay 10% of its asset value for breach. Just now you have mentioned a provision, isn't it? Just now you have
Yes.
mentioned a section for punishment of fining the company if there is a breach. If the breach is big, then 10% of the asset value of the company has to be paid as a fine. Under which provision, under which section of the data protection bill you are quoting it? It is being. Can you name that section or
Yes.
provision?
1 minute, sir. I will. 1 minute. Yes, sir. The section is the section 43A in the bill, in the IT rules of 2011.
Okay. IT rules, information technology rules. Under
Yeah.
Information Technology Act, it is not under Data Protection Bill.
Yeah.
Okay. It is not under this provision, this act. No, he is posing under this act whether there is any such kind of provision for punishing the government authorities or the private institutions who misuse or abuse data of private citizens or citizens in general. Where there is any such provision. If there is no such provision, then you can move a bill to incorporate. You can move an amendment to incorporate such provision. Would you like to move any such kind of bill?
Sir, yes, sir. We would like to amend clause 12, sir, section 12, clause 12. So it only tells that chairperson or the member of the authority will be removed in case of central government will be removed from the authority and only dismissal. After that, it's not mentioned what are the IPC charges he is liable under. So we would like to move an amendment of the clause 12 so that all of that which is present in IT Act 2011 should be incorporated added as subclauses to the clause.
No, why? Already there is a separate legislation. It's already on statute book. What is the purpose of incorporating once again in the statute? Already that law is in existence. If it is not enforced here, it can impose under Information Technology Act, isn't it? No, I'm posing is that what is the purpose of incorporating IPC charges? Indian Penal Code is separate penal code. You can bring penal provisions under this act. Just like in the other act, have gone through the Aadhaar Act, where there is misuse of Aadhaar by any of the private or government authorities, the maximum sentence is 7 years. Up to 7 years, they can be punished. In the same way, there has to be a penal provision in this data protection bill. You can bring such kind of penal provision under this bill. Under this special legislation. It's a special legislation, isn't it? Exclusively catering to the needs of data protection. But if there is any data protection or data misuse, you can bring a penal provision. You can bring an amendment bringing a provision punishing those people who are misusing or abusing by proposing certain punishment or fines. You can bring a amendment to that effect. Instead of making the general provisions under IPC, IPC is general act under general crimes. It is a specific purpose this legislation has been brought. For the specific purpose, that there will be a specific crime incorporated under the same legislation. Instead of going to the other legislation.
Sir, there is a clause in this bill, sir, in Chapter 10, Penalties and Compensation. It says that it shall be liable, the data fiduciary shall be liable to a penalty which may extend to 5 crore rupees or 2% of its total worldwide turnover of the preceding financial year, whichever is higher. So, the failure to adhere to security safeguards as per section 24 or transfer of personal data outside India in violation of in violation of provision of chapter 7, it shall be liable to a penalty which may extend to 15 crore rupees or 4% of its total worldwide turnover of the preceding financial year, whichever is higher. So these are present, sir, for the penalties.
Yes. Okay. Fine. Anyone? Any parliamentarians would like to bring any points?
Sir, I would like to say clarification. This was the case for a private organization. What does the government plans to give it as a compensation when it's done by central authorities?
So you are saying that provision is only exclusively in relation to private institutions, sir?
Yes, sir.
I
They have
suppose it is both private and government. He's stating that the penalty lies for both private as well as government.
Sir, here it is not mentioned as a private data fiduciary or anything. It is generally
It is
mentioned
for,
as where any data fiduciary without any reasonable explanation
yes, that means it
fails
includes
to.
both government as well as private.
Yes, sir. And there is another
According to
point
you.
where it tells that where any data
Hmm.
fiduciary without any reasonable explanation fails to comply with any request made by the data principal under Chapter 5, such data fiduciary shall be liable to a penalty of 5,000 rupees for each day during which such default continues, subject to maximum of 10 lakh rupees in case of significant data fiduciaries and 5 lakh rupees in other cases.
Okay, okay. Fine. It's over, or any points would any of the parliamentarians would like to make? Fine.
Yes, sir. Yes, sir.
Okay.
Any parliamentarians wanted to make any further points? If yes, please raise your hand. Or a Google Sheet is provided in the chat box. You can express your views through that form also. This is the last call. If you want to make any further points, you can raise your hands.
So there is one point actually under the bill. When the offense is under this act is committed by the Department of Central or State Government, the authority of the state, the head of the department or the authority shall be deemed not only the head but the whole authority through which the breach has been performed will be will be seen as fault offense. The offense is considered
Under
by
this
whole authority.
under this provision, data protection.
Yes, sir.
What is the provision? Section number?
There is something. Actually, I've searched in internet. 96. There
No,
is
no. I'm posing to you under this data protection bill. What is the provision you are quoting under this data protection bill, or something else?
data protection bill only. Offenses by central and state governments department. There is.
So there is a chapter.
Yes, sir.
What is the chapter under? From which provision it's starting? From which section onwards it's starting?
96.
96.
Yes,
Section
sir.
96. Okay.
Yes.
Okay.
Sir, we just wanted to ask, sir, isn't this the breach of the decorum of the competition? Sir? Internet is not the means how the clauses and chapters have to be quoted. It has to be quoted through the bill. But we believe mere extension.
No. We are saying that in the bill there is already a provision incorporated under section 96 onwards that if there is any violation on the part of the central or state government authorities, then they will be punished. There is a penal provision which is incorporated. It's stating that. That is his point.
Okay.
Okay.
Okay, sir.
Okay.
I guess this is the conclusion for the rebuttal round. And as the last call was also completed, sir, shall we move to the voting, sir?
Yes.
Yes, sir. So the question is, the bill is passed or not?
Yes.
The bill that has amended be passed. Those in favor of the statement may raise their hand. Those in favor of the bill may raise their hand. Honorable parliamentarians, those in favor of the bill, please raise your hands. Sir, the count is 5, sir.
Mhm.
Please lower your hands. Honorable parliamentarians, those who are against the bill, please raise your hands. Parliamentarians, those who are against the bill, please raise your hands. So the count is 3, sir.
In favor of?
In favor, 5, sir. Against, 3, sir.
Mhm.
Please lower your hands.
Only 8 members. Okay.
Yes, sir. There were a few participated but have left in the rebuttal round, sir.
Okay.
Yes.
I guess, yes, the bill is passed by the majority, simple majority.
Yes, yes, sir.
Okay.
Um, Thank you so much, sir. Thank you so much, parliamentarians, for participating. I take the privilege to thank the Honorable Speaker Randir Garu for accepting our invitation and taking your time out and being a part of the event, sir.
Yes,
I
thank
would
you.
take I would take the opportunity, sir, for your feedback. Enlighten with your words, sir.
Every one of them have participated very well. Every one of them have, in fact, gone through the protection bill. It is not that they have presented vague points. They have presented the points that which are essential, and in fact, they should have at least gone through certain uh, judgments that which were rendered by the Honorable Supreme Court very recently in relation to the data privacy. So the data privacy is not only starts from this data protection bill, but it has its origination in the Information Technology Act 2000. Then there is an Information Technology Amendment Act 2008, wherein there is provisions for the protection of the data, but those provisions are not especially in relation to protection of the personal data, but for the purpose of misusing of the private information that which is collected. And one can in fact go through the Electronic Devices Act and Telegraph Act and misuse of personal information, where one used to snoop by the intelligence officials if there is any such kind of snooping, as one can refer to the Neera Radio cases, wherein the Honorable Supreme Court has stated that right to privacy is fundamental right, and which is part and parcel of Article 21 of the Constitution of India, which speaks about no person shall be deprived of right to life and personal liberty except according to the procedure established by law. And very recently, just 2 days ago, on January 28th, Honorable Supreme Court has rendered a judgment in relation to the expulsion of 12 BJP MLAs from Maharashtra State Assembly, wherein the Honorable Supreme Court has categorically stated that the Assembly, or for that matter, any parliamentary house or the Speaker, has to function in a very sober, within the rules of parliamentary rules of legislation, without jeering or making any abusive language, and the power of the Speaker has been curtailed. So, by keeping all that in mind, I suppose everyone have gone across every aspect of the bill and they made their points. And I'd like to congratulate each and every one of them for participating. Despite being engineering students, you have gone through all the provisions and you have done your research to that extent.
Yes, sir. Thank you so much for the feedback, sir.
Okay.
I congratulate all the parliamentarians for their active participation and hope this event benefits you. I request all the parliamentarians to turn on your videos. We want to take a picture to preserve memories.
Okay.
I request all the parliamentarians to turn your videos on. Yes. Member 25, Parliament. Yes. Yes, sir. Thank you, everyone. Thank you for participation. Thank you so much, sir.
Thank Thank you.